In this video, you're going to learn about federal criminal indictments. There's two ways that you can be charged in federal court. The first is a charge with an affidavit by a law enforcement officer, and the second is going to be an indictment, a federal criminal indictment. That's handed down by a grand jury. A grand jury sits and hears evidence. Unfortunately, they only hear evidence that is brought by the prosecutor, and other than some very rare scenarios where defendants have spoken in front of the grand jury, that often does not happen, and the old saying is that a grand jury will indict a ham sandwich. They'll indict much more than just a ham sandwich. They will indict on almost every single case a prosecutor brings to them. But that's not why grand juries really exist. Grand juries are used as an investigative tool by federal prosecutors. Grand jury has the ability to issue any subpoena the prosecutor asks for, and that information must be kept secret to the grand jury until it is later disclosed in discovery. It is the way that federal prosecutors are able to keep their investigations absolutely secret. And why is this important? Well, this is important because if you are the target of a federal investigation, it's often very difficult to know whether or not you are actually the target. The grand jury's work is going to be secret. And then one day, an indictment is unsealed and it contains a list of names, many of whom may have never been aware that they were facing a federal investigation. If that occurs, a clock starts and you are already behind. If you are named as a defendant in a federal indictment, chances are the government has had a year, 2 years, maybe even 3 years head start on gathering all the information they need to gather, and they are very well resourced. This is one reason why an early investigation, as soon as you learn that you may be the target of federal criminal charges or a federal criminal investigation, you've got to get to work and start working to gather evidence, preserve information, and prepare for your trial even before an indictment. And that's one of our principles here at Chapman Law Group. We start our preparation early and we don't stop until the case is over. There's a lot of wishful thinking out there. People hope they're not a target. People believe they're not a target. People convince themselves they're not a target. But unfortunately, in some cases they are. And if they've lost a lot of time and failed to prepare their case, they can be in some big trouble and may not be able to win when it comes time to bring your case to trial. So early preparation and investigation is going to be vital in ensuring that you can survive a federal criminal indictment. So when that indictment is handed down, there's something called an arraignment. We've got an article on the website related to arraignment as well as one related to indictment if you'd like to stop and take a read of that. But at arraignment, the judge is going to ask you how you plea, and then there's going to be the big question related to bond. Most federal defendants are bonded out. However, those related to violent crime and drugs may have difficulty bonding out. In drug cases and violent crime cases, there's something called a presumption of detention, and that can be a very, very difficult thing for a defendant to overcome in some situations. And what that basically means is that when the federal judge and the magistrate look at your case to determine whether or not you should be detained, they're going to see that the allegations relate to something very serious which could cause a risk to the public. The concern there is that if they release you and you commit a crime or you hurt somebody, that there may be a lot of public backlash. And so one of the things that we do prior to a bond hearing, even before we learn of the indictment during the investigative stage, is we prepare those arguments for you as quickly as possible to show your peaceful nature, to show the assets that you have in the community, to show your stable family environment. And we prepare witnesses to make sure that you stay out, because staying out of jail pending resolution of your federal indictment is going to be one of the most important indicators of the potential for victory. Let me say that one more time. If you are able to stay out of jail pending your federal indictment, you have a higher chance of succeeding in your case. That's a very important stage of the case, and we shouldn't mail that in. Many defense attorneys do, but we fight as hard as we can for our clients at that stage. Then we get ready for trial. And one thing's for sure is that we know how to try a case. Over 150 counts of acquittal, $550 million back for our clients, saved in fines and forfeitures, and counting. Our attorneys are trained to take a case all the way to trial. But if a plea is something you're looking for and that's a resolution that you want and that you accept and you believe is in your best interest, we have the ability to negotiate the best plea possible. Federal and criminal indictments are a very, very tough thing to deal with. The federal government is a very strong and powerful leviathan, and you need to fight as hard as you can in order to ensure an early call might save you a whole lot of hassle and increase your chances of victory in your case. And then feel free to reach out and give me a call if you want to talk about your case or a case that you're aware of so that we can jump on board and defend you.